Well, family courts are called courts of equity, not courts of law. And typically an equitable matter is something that can't be quantified in dollars, and so there's usually a non-dollar solution to an equitable issue. Marriage used to be a covenant for life, and if someone broke that covenant, it was difficult to come up with a dollar amount that would satisfy that breaking of a covenant. And so what happened is they would have a judge come up with, well, what is a fair solution to this situation where maybe both people were working, but maybe one person was not working and the other one was? How can we come up with something that works for both of those people? And if you have a really nice judge and a friendly courtroom and very simple laws, that's not such a bad idea. But what we have today is 2,000 pages of family code.
You said there's 2,000 pages of this legislation regarding divorces. Can you talk about when that came to be?
The transition occurred primarily in the 1970s and 1980s. Prior to 1969, we had what was called the fault divorce system. You had to prove that your spouse did something wrong, like adultery or abandonment or brutality, in order to get a divorce. In 1969, Governor Ronald Reagan in California signed the first no-fault divorce law in the United States, and most of the other states quickly followed, where you could file for divorce unilaterally, but you just couldn't finish the process without a judge.
Politicians who benefit from no-fault divorce have actively worked towards liberalization of divorce laws over the recent past. Older governors who were mostly male were more likely to preside over the passage of no-fault divorce laws, partly because they had gone through divorces themselves. Interest groups massively influence policy outcomes. These interest groups are relatively small, composed of identifiable members, and lobby for legal outcomes. People who want to exit their unions definitely stand to benefit from the liberalization of divorce law, as they wouldn't have to bribe their spouses to allow exits from their unions. While women provide most of the services early on in the marriage, men provide their services later in the marriage. Traditional marriage that were difficult to exit enabled husbands to commit to the promises they made to their wives later on in the marriage. Under fault-based systems, middle-aged women, who had already provided the services required of them early on in marriages, demanded large sums to agree to the termination of marriages. Under no-fault divorce laws, husbands do not require their wives' consent to end marriages. In California, for instance, an association of divorced men called United States Divorce Reform Incorporated, who felt they had been treated unfairly in their divorces, organized amidst California's no-fault reform process to have divorce removed from the purview of courts. If these men can influence policy formation, such as being in positions of political leadership, then they don't face the challenges faced by other men. Their lobbying efforts could be direct, have far lower costs, and be more persuasive. Apart from the influential men who would have had specific interests in reforming divorce mentioned at the start of the video, abused spouses who wanted out of their marriages would also be instrumental in the support for divorce law reforms.
The first sign is what we call harsh startup. Harsh startup means we need to talk. The harsh startup is you did it again. The harsh startup is beginning the conversation already abruptly, already negatively, and already with a hostile attitude. Well, the next sign is actually four things. Gottman calls it the four horsemen. It's defensiveness, contempt, which we've already talked about, criticism, and stonewalling. Those are the four horsemen that together make up the next sign of divorce. Now, what is stonewalling? Stonewalling, which is when one person in the couple is just not responding. Stonewalling is, yeah, okay, yeah, sure. Maybe looking out the window, you're having a conversation, but they're not looking at you. They're not really telling you how you feel, how they feel. You don't really know what's going on inside of them. Appears like that person doesn't even care. The next sign is very much related to the previous four. It's called flooding. Flooding is when you have so many feelings that you can't even speak them. So they're so flooded with feelings, they can't tell you how they feel. It's not that they don't have a feeling. They've got so many, they can't pick one. And flooding is very dangerous because it leads to the next sign. The next sign is physiological distress. If you've been allowing the conflict in your marriage to go on for so long, the anger to not get resolved for so long, you're going to start having physical problems. You're going to start having ulcers, backaches, neck aches. You're going to start drinking more. You're going to start having physiological problems. You're going to start failing from the inside. The last two signs of marriages that are in distress that leads towards divorce are bad memories and failed repair attempts. What does bad memories mean? What it means is you interpret history negatively. You're only remembering the negative things from the past. It's like, yeah, I remember our wedding. Yeah, he was late. He was late to that. He's still late today. You forget all the good things and you remember all the bad things. You're reinterpreting history negatively. Bad memories, bad sign, leading to bad things in your relationship. And the last thing is failed repair attempts. This is really critical. Everybody fights. Even good marriages fight. Fighting in a marriage is not a problem. The problem is, what are you going to do about it? And the really critical thing is to be able to repair what you did. Fighting isn't a problem. Not being able to repair it is.
I've stayed up many nights sitting in the corner with my back to the wall because I've been afraid that he's going to actually kill me. He's told me that I'm going to kill you. His mood would change for no reason at all, and he'd get mad over nothing and just start throwing things around, or, if the kids happen to be in the way, they'd get thrown around too.
It usually happens between 4 and midnight, when men, overwhelmed by their own frustrations, come home and beat their wives.
Your number 55416.
Police receive hundreds of calls every day here in the dispatch room from desperate women crying for help because they're being hurt at home by men they care about, men they love, their husbands. Those women who call are only an estimated tenth of the women who are being battered. Some experts believe that as many as 50% of the married women in this country have experienced some kind of mental abuse.
He would call me everything from, well, you name it, I was that.
And or physical violence from their husbands.
We were coming home and he decided he didn't like me talking to someone at the place that we were at, and just started slapping me and just kept on slapping me until I couldn't get out.
No-fault divorce law redistributes resources from the abusers to the abused who had more incentive to exit marriages. Unilateral divorce benefits spouses prone to abuse by raising the cost of the abuse, as the abuser has to offer larger payments to either keep the marriage or facilitate the divorce. Some sources report a decline in intimate partner violence following the implementation of unilateral divorce. Abused partners are smaller groups of people, but they're more recognizable through battered homes and related organizations.
He would beat me in front of my children. I mean, he didn't care. It was, my children would be in bed, sound asleep, and I would run into their room figuring that he wouldn't come in, and he would beat me right in front of them. They would wake up screaming, crying.
What's the worst thing he ever did to you or your kids?
The worst thing? I guess dropping my kids on their head. We had cement floors, and he'd pick them up and drop them on their heads. There's times that I'd look around for something to kill my husband. I wanted to kill him because I couldn't stand him hurting my kids, but at the same time, I couldn't do anything about it.
Some women have fought back and killed their husbands. After 5 years of being knocked down, beaten up, chastised, Cindy Hutto shot her husband in the back while he slept.
And he was laying down, and he wasn't looking at me, and I just pulled the trigger, and Bubba moved a little bit, and I was so scared he was going to get up and get me again, so I shot him again.
Francine Hughes was abused for 13 years. Finally, one night, she decided to end it.
I started dumping the gasoline around the floor. I didn't put any on the bed. It was on the floor. And it was like everything I was doing was so easy. It was like it's the easiest thing I had ever done in my life. And when I was pouring it, I just kept, there was like an urgency. Do it, do it, do it. Don't back out, just do it over and over and over. And then I backed out of the bedroom, and when I don't know if it was a lighter or matches that I had, but when I struck the flame, and I stuck my hand in, right at that minute I thought, oh my God, what are you doing? But it exploded.
Both of those women were acquitted of their crimes. Many others were not. Certainly, more violence against violence is not the solution for women who already feel like prisoners in their own homes. But the question is always asked, if these women who span the scope of ages and backgrounds, some are secretaries, lawyers, teachers, nurses, reporters, housewives, if indeed they do hurt so badly, then why do they stay? Some of them will answer that question tomorrow. Oprah Winfrey, Channel 13, Eyewitness News.
We fought the public accommodations fight 10 years ago with the blacks. Are we going to have to start all over again with women?
How about, would you like a sign up there that said blacks only or whites only? It's the same principle, sir. Women are persons, women are people.
And we want to be able to come and go through it, and we don't want to be intimidated by signs that say men's buffet.
I have no intentions of taking the sign down or changing the sign. If you can get a court order to take it down, fine.
You have no intention of changing your policy of segregated facilities. Is that correct, sir?
If you women are that hard up for a glass of beer, I'll be glad to serve you at the bar.
You know, sometimes the events of decades can crystallize in a moment, and it seems as if overnight there's this historic change. When you look back at it, you say, oh, well, this was building up, and for years there was this person and this person and this group, and they were networking and this, and then there was a shift. The women's movement had many origins. In part, it owes its renewed birth to the civil rights movement, because there was then a lesson for the women of America of how blacks at that time were taking their life into their own hands.
Is my bacon ready yet? 20 past 8. Some more toast, Teen. Hey, Teen, why don't you get cracking on a thorough fall house cleaning campaign around here? Get the floors waxed, get the windows washed, get this place looking as if civilized people are in residence, Gee, that's a little light, isn't it?
I'm sorry, I hurried it.
Sweetie, have a little more damson plum preserves, please.
Years ago last year, women got to vote, I hear, but we just sat on dusty shelves because we never helped ourselves. Married men can still be free, but a woman, what is she? A servant with no pay for life, just so she can stay a wife. A status symbol with a ring. Tell me what that's gonna bring. A legal right to bear his kids while liberation he forbids. So ladies, drop the kitchen mop and we'll be heard somehow. Men have made a mess of things. They should be stopped by now.
Surprisingly, women's advocacy groups in the United States didn't exactly support no-fault divorce. Feminists' interest groups didn't particularly appear to be interested in discouraging the implementation of unilateral divorce reforms. For instance, Wisconsin feminists initially supported unilateral divorce laws initiatives of around 1975. After learning that unilateral divorce would disadvantage women compared to dissolution under fault-based systems, they sought to impede unilateral divorce. Feminists sought to introduce alternative divorce reforms that would benefit women financially. Similarly, the New York chapter of the National Organization for Women opposed unilateral divorce reforms, although it was supported by the Women's Bar Association. A common recurrent theme as it pertains to feminist support of divorce reforms is pronouncements on marital property. Otherwise put, depending on the presence or absence of marital property changes, which influence divorced women's welfare, especially materially, women's advocacy groups lobbied for and against the liberalization of divorce laws.
Most women are raised to believe their true role is that of wife and mother, but some women are questioning whether this is so. Is this the true role? Do I have to get married? Do I have to get pregnant? Do I have a choice? Birth control, especially the pill, provided women the choice. At this clinic in Washington, and clinics like it all over the country, and privately in doctors' offices, millions of women started taking the pill, and they had unprecedented freedom from unwanted pregnancies. But there were questions about the pill's safety, and in Senate hearings on it in January, there were many who said that the pill can be dangerous. Of the first 18 people to testify at the hearings, none were women, but women went anyway.
You are not going to sit quietly any longer. You are murdering us for your profit and convenience. Who is going to pay the medical bills when a woman develops cancer of the breast or cancer of the uterus? Are you going to give us free medical care?
No, we want to have some control over the decisions that affect our lives.
All right, will you please sit down or be removed from the...
No, we aren't going to sit down. Why don't you give us some solid answers to our questions? You're going to take women, you're going to drag women out of this hearing whose lives are at stake. That's a fine way to run something. You cannot pull us out of here. These questions affect our lives.
The 1960s and 70s ushered in big changes for women in America. From family life to the workplace to reproductive rights, there was a charge for change known as the women's rights movement. But long before then came the fight for women's suffrage, which granted American women the right to vote in 1919. That movement, led by Susan B. Anthony and Elizabeth Cady Stanton, paved the way for the second wave of feminism in the 60s and 70s. In 1960, family planning was transformed as the FDA approved birth control pills for contraceptive use, opening a new chapter for the career women. About 3 years later, at the urging of Esther Peterson, President John F. Kennedy signed the Equal Pay Act. Also that year, Betty Friedan published The Feminine Mystique, which documented what she saw as the oppression of middle-class women.
We're all housewives when in the beginning and in the end, although we have to be much more than that in the world now.
By the 1970s, women of all ages, races, and backgrounds had joined in the fight for equality. Gloria Steinem campaigned for a constitutional amendment to guarantee equal rights for women. And in 1972, Congress passed the Equal Rights Amendment.
Hey, what do you say? Ratify the ERA.
Because there was this big rush to get divorced, and frankly, primarily by women who were caught in bad marriages prior to no fault, they suddenly wanted to go through this process, but they found that the laws had been written to address the old patriarchal system where the man was the king of the castle. And so many of the laws that pertain to the patriarchal system no longer pertain to the women's lib movement and women having independence. And so the legislatures, under the lobbying from the National Organization of Women and other groups that advocated, I think, very favorable changes to the legislation, logical and good-spirited changes to the legislation, kept writing in all these new laws to put in these new protections, but as in many cases, the law of unintended consequences set in. And so a lot of these laws that were written in the 60s, 70s, and 80s were a good idea at the time, no longer necessary, and create much of the confusion and animosity that we see today in family court. To get divorced, you can't simply fill out a form that says I'm divorced. You have to go to court, and a judge has to approve the divorce. And breaking up is traumatic on its own, never mind having to go to court and appear before a judge and trying to learn enough about the law if you can't afford to pay a lawyer to do it properly. And if you can afford to pay a lawyer, well, then they often take most of your money. It's the fourth most common cause of bankruptcy in the United States.
It's not surprising that the average contested divorce in the U.S. costs $50,000. In the last 40 years, the number of divorce lawyers has exploded, increasing over 2,000% in California alone.
So the average cost of a non-contested divorce would be between $10,000 and $20,000 typically. And for a contested divorce, it's $50,000 plus. And, there's some divorces that cost $20 million.
Family law or matrimonial lawyers benefit from increased demand for their services. Hence, they would be financially motivated to support any laws that raise the incidence of divorce. Organizations such as the American Academy of Matrimonial Lawyers are well positioned to influence divorce law reforms. The fact that entry into the legal profession is restricted means that matrimonial lawyers are highly concentrated for a large populace of those who consume their services. Family law specialists, mostly divorce lawyers, drafted the divorce laws that informed the Revolution through drafts and testimonies. The National Conference of Commissioners on Uniform State Laws and the State Bar Associations were instrumental in standardizing and promulgating no-fault legislation. The implementation of unilateral divorce witnessed a rise in litigation among spouses, which reflects the financial incentives for lawyers to support unilateral decisions. The fact that the most significant attorney interest group in the U.S., the American Bar Association, seems to have been a strong proponent of divorce law reform is suggestive that there is a financial incentive for family lawyers to support divorce reforms. In fault-based divorce systems, spouses negotiated financial and custody arrangements before heading to court, effectively reducing courts into rubber stamps. Under unilateral divorce, the initiating spouses reaches out to a lawyer without their partner's knowledge, makes some of the most ridiculous requests that would force their partner to retain legal counsel, then they head to court. Issues such as the award of alimony, other financial agreements, and child custody are settled in court. More issues to solve in court means more money to retain legal counsel, who are costed by the hour, hence lengthier divorce proceedings. In fault-based divorce laws, courts had already pronounced themselves on the degree to which a partner was responsible for the breakdown of a relationship. To establish the cause of relationship breakdown, courts had to establish extensive inquiries, which increased the length of litigation. One purpose of lawyers in divorce was eliminated in the absence of the proof requirements. Although many lawyers intervene in instances of third-party mediation where spouses drafted their own requirements, the prospects of losing their market to non-lawyer mediators could inform shunning divorce law reforms. The state bar objected to a 1966 proposed Californian ballot initiative that, in reforming the state's fault-based divorce regime, would have removed divorces and related family law issues from the courts, and placed these matters before an administrative department of family relations. It could be the case that unilateral divorce streamlined divorce, thereby reducing the length of litigation, but the lawyers could be smart with the whole thing. The lawyers who opposed unilateral divorce reforms on the grounds that they streamlined the process appear to have been the minority. The final group that could have been interested or not interested in divorce law reforms was the church, which for the most part is against divorce.
A big topic that you spend a lot of time on in the documentary is these problems with the lawyers and these outrageous legal fees. But if people are willing to pay them, I mean, that's their choice. What's wrong with that?
I'll tell you what's wrong with it. I think it's an oligopoly. You say, well, it's a free market. Lawyers can charge whatever they want to charge. However, they've made the laws so complex that you pretty much have to hire these specialty lawyers that are divorce lawyers. There are only a certain number of them, and that drives up their hourly rate.
And it's complicated because the judges have special relationships with a lot of these lawyers.
And unlike other public officials, judges do not have a waiting period between public and private practice. A judge can retire one day, practice as an attorney the next day, and then go back to being a pro tem judge a day later.
Judges will oftentimes try to get very cozy with the law firms that they want to work for upon retirement as a judge. And so it creates a conflict of interest. The other conflicts of interest is lawyers are allowed to contribute to the election campaigns of judges, appear before them in court, and yet give them money toward their election campaigns. And so I'm afraid what that does is it can allow certain law firms to buy influence with the judge. Or if it's not direct campaign contributions, it could be things like appointing the judge to some committee that's a prestigious committee, or throwing a fundraiser for the judge.
The Church has constantly presented marriage as an indissoluble sacrament, even though Protestant churches, such as a committee appointed by the Archbishop of Canterbury, recommended a form of no-fault divorce as early as 1966. Church leaders have historically opposed the award of powers to nullify the sacred marriage institution to secular authorities. The dual threat that divorce law liberalization posed to the Church, on the one hand to its doctrinal interests and on the other to satisfying important segments of its membership, provided church leaders with strong incentives to oppose no-fault or unilateral divorce reform. The church instead supported the formation of some special family court that focused on counseling unhappy couples as an approach to reconciling the marriage. Evidence suggestive of the church's influence on the American no-fault divorce revolution, or rather, in delaying it, is found in the fact that states with large Catholic populations were among the last states to pass divorce law reforms. Massachusetts and Rhode Island reformed their divorce laws in 1975. Pennsylvania did so only 1980. And Illinois held out until 1983,